Hey guys, I'm doing another video. This is about the rise of Bitcoin and how it impacts the crazy Celsius clawbacks and why they've become even crazier. Videos for educational purposes. Don't take any action based on this video. Don't refrain from taking action based on this video. And if you're being sued by Celsius or otherwise being impacted, hire counsel. This video is not being made on behalf of any particular client. It's for educational purposes and does not constitute a waiver of any kind. So the big question is, if creditors are being paid 100 cents on the dollar, which is a big if, then what's the impact if you have a preemptive 502H claim? So I'm going to be going into case law that talks about what happens when there's 100% payout post-petition, both in the context of a plan of reorganization and in the context of liquidation. I'm going to be talking about 502H. I'm going to be talking about the value of the 502H claim that's been issued in Celsius, what it might be, what it might not be, and I'll be concluding. So the basic concept of a preference is based on insolvency because the theory is that one creditor is being paid 100 cents on the dollar pre-petition. When other creditors are not getting paid, they're getting paid a small percentage on the dollar post-petition. In other words, when this creditor got paid pre-petition, the debtor did not have enough assets to pay everybody in full. And all the other creditors did not get paid in full. So there's a fairness argument that this creditor that got paid in full pre-petition right before the bankruptcy case, and it's an arbitrary 90-day window that's considered right before the bankruptcy case. It's unfair that that creditor gets 100 cents and everybody else gets bupkis, gets 3 cents or whatever is left over. So that's the basic theory of a preference law, obviously simplified. So what happens if there's 100% payout after the petition, after the bankruptcy, and the debtor becomes solvent after the bankruptcy case? What happens then? So you'd think, okay, now we're solvent, so problem's over. So no one should be sued for clawbacks because everyone's going to get 100 cents on the dollar. That may or may not be the case. I'm going to take a look at some cases real fast. Also taking a look at this section right away. This is what governs the payout to trustees or creditors committees or debtors or anybody acting in the shoes of a plaintiff in a clawback case. And what it says is that the trustee may recover for the benefit of the estate. And the big question that judges have struggled with is that if the company is solvent post-petition after the bankruptcy, does it benefit the estate to continue with clawbacks, or should clawbacks just be dismissed? That's exactly what happened here. There was a bankruptcy, there's a clawback against another entity, and the entity argued there should be a cap on this clawback because we're being sued for way over what's necessary to make creditors in full. Well, summary of what happened here is that there was a plan of reorganization that was negotiated among creditors. Some creditors agreed to take less, and the plan was confirmed because those creditors were given rights to this clawback. And so the judge said in this situation, there is a benefit to the estate. The benefit to the estate is that a plan was confirmed because there was a deal made that a certain group of creditors would get rights to this clawback. And it doesn't matter if they're getting paid way more than their claim amounts because there was a benefit to the estate. So that's the ruling, simplified. And you can read. I'm not gonna go through the case. You can read it. This case was faced with a similar issue. It's after the Tronics case, which was the case we just looked at. So again, the defendant was making a similar argument that there should be a cap. And the plaintiff was arguing, citing the case we just talked about, saying, no, there shouldn't be a cap because it's for the benefit of the estate. And the judge, this is called the capping motion. And the judge basically said, there is going to be a cap here because this is a Chapter 7 case. There was no plan of reorganization and there was no benefit to the estate. There is no benefit to the estate by recovering way more than what creditors are made whole with. So it's opposite, but different fact pattern. In the other case was a plan of reorganization and there was a discernible, arguable benefit. Here is a Chapter 7 case, and the money, where would the money go if not to creditors? It would go maybe to admin, but that's included in creditors. So where would the money go? There's no reason to continue with the clawbacks. That was the rationale in this case. And again, you can read it. So in the last 5 minutes, you could see that applying 550, there may be an argument that claims should be capped, or there may be an argument that claims should be not capped. But this is an entirely different argument based on an entirely different section of the bankruptcy code. And there's an argument that clawbacks should be dismissed based on this section, which is a whole different argument. 502H. And what is it? What is it about? A lot of people get confused about this when I talk about it. It's not that complicated. 502H gives you a claim. If you pay money or assets pursuant to a clawback, you return assets or you pay money into the estate, you're going to have a claim against the estate. And the theory is the clawback is not meant to punish creditors that got 100% payment pre-petition. It's just supposed to put them in the same position as other creditors that didn't get paid during the preference period. So this is what this accomplishes. You pay back you pay back the clawback, and you get a new claim like everybody else. So in other words, you pay back your 100% recovery, and you get a claim for the amount that you're paying back. So you're getting a claim just like all other unsecured creditors, and it's treated as if it were filed pre-petition, like all other unsecured creditors. Not complicated. I'm sued for a clawback. I pay 100K back to the estate. Either I'm paying a judgment for 100K, the whole clawback, or I'm settling the case for 100K. Whatever I pay back to the estate, I get a 502H claim in that amount. 502H claim in that. So it comes back to me. I get a 502H claim. I get paid. Now, I get a 502H claim that's treated like an unsecured creditor. So if there's a payout of 50 cents, I'll get back 50,000. Usually, I'm not going to get paid back right away. I'll get paid back when the estate is making distributions to unsecured creditors. And I'll get paid back in the same proportion that other unsecured creditors are getting paid back. So I don't get 100K back, I get a claim for 100K, which is a 502H claim. It's treated as if it were just a regular pre-petition claim, unsecured claim. So I'm going to get paid what unsecureds are getting paid on their money. In this case, which is unusual, the plan gives you a preemptive 502H claim, which I'll talk about later. I'm going to go through quickly some cases and some briefs talking about 502H. There's very little case law on 502H. So the reason for that is that typically a trustee or a plaintiff, not a trustee, a creditors committee, whatever, is going to ask you to give up your 502H claim. That's par for the course. It happens. I've been doing this 20 years. I think it's happened every single case. That's part of the negotiations. During settlement discussions, I'm going to be asked that the client give up a 502H claim. And typically, we do. It's not a lot of, usually the payout is small. It's not a lot of money. And it's part of the negotiations. It's just not worth a lot. So it's not something, the 502H is not something that's litigated. There are very few cases on 502H. This is a brief. You can read it. It's just some verbiage to help you understand what a 502H is. Yeah, this is an interesting case. So basically what this case says is, well, someone tried to set off a 502H claim. And the court said, well, you can't set it off because it doesn't exist. In other words, you're being sued for a clawback. Let's say you're being sued for 100K. And then you say to the plaintiff, okay, well, I'm going to have a 502H claim worth 25K. Or if you're an administrative claimant and you're a higher level claimant than an unsecured creditor, you're being paid 100 cents on the dollar, which I think was the case here. You're going to argue, I'm not going to pay the clawback. I'm not going to pay 100K because I'm going to have a 502H claim for 100K. So let's just set it off. And this judge said, you can't do that because the way this court read the statute is you don't get a 502H claim until you actually pay on a clawback claim. So it doesn't exist. It's a future claim. And that was the position of this court. There's another brief. It's just talking about 502H. It's not very important, really. Right. There's no case law. There's very little case law. So what's the futility? A futility argument is something that may be applicable in Celsius. So I'm going to talk about it a little bit. It usually plays, and this is a memo of law, it usually plays out in the case law The situation is that there's a claim holder that has a higher level claim, like I said before, like an administrative claim that they're going to be paid 100 cents on the dollar for. And so there's an attempt to argue that stop bringing a clawback against me. It's futile. Why is it futile? Because I'm going to be paid 100 cents on the dollar on my 502H claim. Why is that? Because let's say I cut a check for 100K, then I get a claim pre-petition, I would get the exact same claim I'm entitled to. Now, the exact same claim I'm entitled to, if I'm an admin creditor, arguably is an admin claim. So I'm going to get an admin claim pre-petition. That's going to be paid in full. So why are you suing me now when I'm just going to get the money back later? And that's basically the argument that's being made in this memo. This is a case that discussed the same thing. This is a brief that's discussing it. We go through fast. Just to point out that the United States Supreme Court actually faced this issue. It recognized it's stupid. It's futile. It's futile to go through this process of suing somebody when they have a setoff, a clear setoff, not an arguable setoff, 502H setoff. And that's what this case also, this is an opinion that also concluded that. And it goes into, and essentially says, in this situation, it's futile. And the argument is that, and the opposition was citing the case that we discussed. You don't have a 502H claim, doesn't exist yet. And this court came up with an interesting opinion and basically said it doesn't benefit the estate. So it's a 5550 argument. There's no benefit to the estate because it's going to be a futile process. It's not saying you do or do not have a 502H claim. I'm saying you will have a 502H claim, but why waste everybody's time? Yeah, so there are some issues raised. So this is the plan section where it says if you have a if the trustee or rather a Celsius has a successful avoidance action, essentially says you got a preemptive set off. Will be preemptively set off against the property to be recovered. So it doesn't say you have to pay first. It says you get set off first. That reduces your liability. Okay, there's some issues that come up in that clause. What is a successful avoidance? Common sense is that includes settlement, or is it just situations where Celsius is getting a judgment? It's not absolutely clear. What's the value? And the most important question is, what's the value of my 502? So it says I have a set off now. I can use this set off right now to set off, arguably, in settlement negotiations, set off a an alleged clawback that's being litigated against me. So the question is, what's it worth? How am I going to set it off if I don't know what it's worth? So if Bitcoin is over 100K and the estate is solvent, then my 502H claim is going to be paid 100 cents on the dollar. So again, it's a futility argument. So it's a huge issue. What is the impact of the rise in Bitcoin if it's over 100K? And how high does it have to be to impact the recovery of unsecured creditors? And what about Ionic? What's that worth? I get a share of Ionic if I'm an unsecured creditor. I get shares of Ionic if I'm an unsecured creditor. What's it worth? It's not trading yet. It has a nominal value of $20. Based on what? Was there an expert report on that? I haven't seen it. I can't find it in the document. Maybe there is. I don't know. But when it trades, arguably the value is going to be different. What's it going to be worth? If Bitcoin is going up and it's mining Bitcoin, you would think the value would be going up. Can I set out? Yeah. So that's another issue. Number four. I don't think it is an issue, but I've heard a rumor that there may be an objection to that, and that's just a rumor. I really don't know. I think it must be absolutely clear. And when should these issues be decided? That's very important because if we're negotiating, if we're going into formal mediation and we don't know what our setoff is, and the estate might be solvent, I think it's gonna be a problem. I mean, you can mediate and have a lot of unknowns. That happens all the time, but it could be a major unknown, and it could um, render these mediations less useful. The other problem is that Celsius, in its negotiations in the past, uh, has been demanding a waiver of the 502H claim to settle the cases. So that puts the defendant in a very tough position because uh, if we keep our 502H, so let's say we don't settle, we keep our 502H claim, and Bitcoin rises, it could be disastrous for us because of the the threat of the in-kind recovery. If we don't own Bitcoin, we have to go out and buy it at these escalated prices. On the other hand, if Bitcoin rises enough and the state is solvent, it could be we're going to get 100% 502H claim, and we don't know when. It could be in the future, it could be now. So it requires us to make an all-in decision and take I think it's a significant risk to litigate the possibility that you'll have a 502H claim later in the case. And a 502H claim is typically uh, determined at judgment or at the time the case is settled. So you're going to have to wait till you get a judgment. That's a huge risk. So that's why what I'm going to be saying is that I think there should be some kind of an estimation process now so that defendants are not put in that very difficult position. Again, it's another irony in the Celsius case. There are a lot of ironies in this case. So one is if the Bitcoin goes up, the rise in Bitcoin increases your exposure if you have to go out and buy Bitcoin. If there's a successful clawback against, there's a judgment against you, and you're even with settlement, your exposure keeps on going up if there's an in-kind clawback with the rise in Bitcoin. But if it goes up enough and it impacts uh, the recovery of unsecured creditor and to the extent that there's 100% distribution or close to it, then there's going to be an argument to dismiss all the clawbacks. So the Bitcoin price has to go up enough, like I said before, and it's an unusual situation. It's a very tough decision. It shouldn't be so tough. There really should be more guidance, more information on valuing your 502H claim. So, because it's preemptive, so you know what you have, you know what you can use. Right now, it's a very difficult decision, and it's a bad way to, in my opinion, it's a bad way to go into mediation. It's a huge uh, case-killing issue, and how are you going to cut checks that are of any significant size? If there's a possibility that there's 100% payout, that was not the possibility before. Before that wasn't even there wasn't even a remote possibility in my mind. But now that Bitcoin has gone up tremendously, and for the reasons described, I think it's a possibility. The problem is there's not a lot of information on these issues. So bankruptcy is known as is supposed to be a fishbowl. That's a term that's used a lot, and what that means is it's a public forum. There's not supposed to be any secrets. It's supposed to be, generally speaking. I mean, there are things that are under seal when appropriate, but generally it's supposed to be a fishbowl. It's supposed to be open to the public, and information should be freely available. That's not my experience with Celsius. I'm not saying there's any evil intent, but I'm just having trouble figuring out the answers to some of these questions with respect to the value of the 502H claim. So if you look at the plaintiffs, I'm going to go quickly. You can take longer if you want. If you look at the status report and distributions, when was this done? I don't have a date here. Basically, what that says is that the reserves are going to be kept in the form of Bitcoin. That's my understanding. There you go, 12/10/24. And then in March, there's a status report, and this is what it says. So these are the reserves. So there's 289 million in Bitcoin. That's what the statement said before. In disputed reserves, and held back pursuant to the plan. I'm assuming uh, uh, funds that are being held back for folks that are being sued for clawbacks, 271. And the footnote, the asterisk said, the chart above in the previous page utilizes crypto pricing as of January 16, 2024. Fine. Then there's a status report recently, last month, and the numbers change. We don't really know exactly why the numbers are changing as far as what's kept in reserve. Is that, and at the end of the day, how much reserves are needed? What percentage of that is ultimately going to be distributed to unsecured creditors? I mean, I think that's an important projection that I'm not seeing here. The other problem is, if you look at the footnote, it says the chart above utilizes crystal as of January 16, 2024. So I'm not following that. If we're in January 25 and the price has skyrocketed, why are we using the old price? It doesn't give me a clear picture of what kind of recovery unsecureds are going to get. And I care about that because I care about the value of a 502H claim. So this just adds to the problem. So you're getting shares of Ionic. So what are they worth? So this is a statement submitted to the SEC about Ionic. And what it says, and this is December 5th, 24. Anyway, I'm looking at this date on the upper left. I'm not sure if that was when it was filed. Anyway, I'm assuming that's when it was filed. It's given, if you look down at the yellow, it's 740 million. That's the value of Ionic, and they're giving it $20 a share. So was that from an expert valuation, or how was that determined? I don't know. I'm assuming it was from an expert valuation. I couldn't find the report. And the question is that still the value, or it hasn't traded yet? It may be trading in the future. I think people expect it to be trading. What's going to be the market value, given that Bitcoin has gone up so much, or may go up more? It says here in an Ionic release that they mined 1,851.14 Bitcoin. So, what is that added to the value of Ionic? Does that impact our recovery? I can't find a report on that anywhere. Maybe there is one, and I just can't find it telling me what's the impact of the rise of Bitcoin on the recovery for unsecured creditors. You would think it's higher. Don't see that anywhere. Yeah. So, is it $20 a share? Is that the nominal value? Is that based on expert reports? It's not the market value because there is no market. You can't trade these shares. So, what's the market value going to be? I think it's an important question. So, here we come to the proposed maybe solution to these issues. There is a claim estimation process in bankruptcy court. I've never seen it done with respect to this exact fact scenario and a 502H claim that has shares and percent of recovery, but there is a process, and it may be appropriate in this situation. I wanted to share this. This I found on the internet, and actually in Westlaw. So it comes from a case. What he's saying is that unregistered shares can be valued by experts. You can get an expert opinion on that. It's not impossible. My report would include, I'm assuming he didn't do it, I don't know if he ended up doing a report or not, but this is a letter from an expert, and he's going to discuss restricted stock that can't be traded, and he's going to he's proposing the ability to do evaluation on that, which isn't shocking to me. I'm sure you can do evaluation of it. Um, uh, the point is, I think it needs to be done. This needs to be done. There needs to be an expert evaluation. There needs to be a process, and maybe an expert from Celsius, and maybe defendants need to retain an expert to find out the current value of the shares, and also a reasonable projection on the reserves, on the current value of the reserves, and what the latest projection is on, well, I'm going to talk about in a second, the value of the tether lawsuit. And I'm going to go through this quickly. I mean, the only point here is that, yes, there's precedent. There's a lot of precedent for starting a claim estimation process. Um, of course, this is Celsius, so this fact pattern, maybe it's out there. I couldn't find it in any precedent. So it might be a case of first impression whether there should be um, an estimation process in this particular situation. But the concept of an estimation process and the protocol for having an estimation and a motion for estimation is not unusual at all. I'm not making any arguments on this video. I'm just pointing out some issues. That's all. Um, so I raise this issue because I think the plan is unclear as far as exactly uh, what we're getting here with our 502H claim. It says preemptive. It says in the situation of a successful case, we're preemptive. What does that mean? Um, are we getting a preemptive claim prior to making any payment? It seems to imply that. Is that based on 5550, or do we need a ruling on that? And I think we need an estimation process. I think the contract is unclear. What are we setting off exactly? We're given a set off, right? And what's it worth? What is it? How are we going to use it if there's no way to judge its value currently? Currently, since we want to use it now, set off in negotiations. And that's just some cases talking about what happens when a contract is not clear, and sometimes a court can supply a determination. I think in this situation, certainly the bankruptcy judge um, might be able to, or might be appropriate for the judge to clear this up. You can read it. Skip. Yeah. So this is the case law applicable. Case law. This is all the precedent that I found applicable to estimating a 502H um, set-off claim. There is none, as far as I could tell. So it doesn't matter. It may be a case of first impression. Doesn't mean it shouldn't be done. Doesn't mean the judge is not going to find it appropriate to have a claims estimation process so ordered in this case. It may be appropriate. So at the time of the transfer, there was no preference period because the preference period is created from the perspective of the past. It's created in the future. It's a future bankruptcy filing that creates retroactively the preference period. So there's no notice of preference liability because it's dependent on an event in the future, bankruptcy filing. If there's no bankruptcy filing, there's no retroactive preference period. Now you have a 502H claim. Typically, the value of a 502H claim is determined at judgment or at settlement payment. But here, you have a right to a preemptive set-off of a 502H claim. Some courts say that a 502H claim doesn't exist until there's a payment. But here, you have a 502H preemptive set-off because it says so in the plan. So you have a present, future 502H set-off that's going to be applied in the past. Why? It's applied in the past because the 502H claim is treated as an unsecured claim that's been filed pre-petition. I hope that's, and to add to that, the valuation of your 502H claim, which needs to be done now for you to have a preemptive set-off, is dependent on future events, such as the trading value, the market value when it trades of Ionic. And that future event can be valued now, as well as the future event, the possibility of a positive outcome for Celsius in the tether loss. It's a future event, but that can be evaluated now in a projection. Hope I cleared everything up. Yeah. So the last thing I want to say is there are a lot of unknowns here. and I definitely do not want to discourage anyone from taking a good settlement, uh, accepting a good settlement offer, as determined by your counsel. Um, I think there were excellent settlement offers made in the past before the rise of Bitcoin. There may be good settlement offers made now. There's a lot of uncertainty, as you could tell by my last slide, or I was trying to be a little bit facetious, but it's true. There's a lot of uncertainty, and there's going to be a probably costly litigation on these issues. So settlement and a good settlement is always an option.